Oh, America, oh, no, no, no. I'm going there the third, I think, or fourth or fifth.
This week.
Yeah, yeah. Oh, to me, if the lecture is bad, then yeah, after that, the best.
Yeah, but you definitely have to. You, no,
No, you
seriously,
have to be ahead of
you
time.
have to be ahead of time. You're right. You're right. 'Cause nobody waits for you.
Absolutely. Then
And they don't apologize for it either. I got there. Actually, it turns out.
yeah, I don't like this process myself. But it after if the event is in the evening, I wouldn't go.
How'd you know? Yeah.
A lot of tolerance.
I went to one place last week. It was pet food.
Oh, yeah, I got,
See that?
yeah,
It was in the, it was in Capital Great Books.
yeah, one lady sent me,
Yes.
it's
Yeah, I know where she is. I know exactly where it's coming from. She wasn't there, but I went to this event.
I noticed that she doesn't go to some of these events. She was really kind to offer me this free service.
Yeah, it's stuff in here.
Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For those here in-house, we would ask that courtesy check to see that our mobile devices have been silenced or turned off. And, of course, for those watching online, we remind you, as well as those joining us on C-SPAN, that you're welcome to send questions or comments at any time, simply emailing speaker@heritage.org. And of course, we will post the program on the Heritage homepage following today's presentation for everyone's future reference. Leading our discussion is Cully Stimson. Mr. Stimson is manager of our National Security Law Program and a senior legal fellow in our Center for National Defense. He is a nationally recognized expert in national security, homeland security, crime control, drug policy, and immigration. He also writes and lectures widely on policy issues such as the law of armed conflict, terrorist detainee policy and interrogations, the Geneva Conventions, military commissions, the Patriot Act, FISA, and others. Before joining us here at Heritage 10 years ago, he served as Deputy Assistant Secretary of Defense for Detainee Affairs for both Secretaries Donald Rumsfeld and Robert Gates. And he has also been a prosecutor at the local, state, and federal levels. He is a third-generation Navy officer and has served as a military prosecutor, defense counsel, and recently served as Deputy Chief Judge of the Navy Marine Corps Trial Judiciary. Please join me in welcoming Cully Stimson. Cully?
John, thank you very much for that way too long but warm introduction. And speaking of warm, we're going to have the air conditioning turned on, so we'll cool down the room a little bit. It's a real pleasure to welcome a former Heritage intern and now Senator Young back to Heritage. He represents the great state of Indiana, which I held my first job in Indiana at the Culver Academies back in '86. He's a fifth-generation Hoosier. He grew up watching his parents work hard to support their family. His first jobs were delivering newspapers, mowing lawns, and providing janitorial services at the family business. After graduating from high school, he enlisted in our great United States Navy, and 1 year later was offered an appointment to the United States Naval Academy. Upon graduation, he accepted a commission in the United States Marine Corps, where he served as an intelligence officer. While based in Chicago with the Navy, the senator put himself through night school at the University of Chicago, where he earned his MBA with a concentration in economics. He later received a master's from the School of Advanced Study in London before returning to the United States to work here, and later as a legislative assistant in the U.S. Senate. In 2003, the senator returned home to Indiana. He soon met his wife, Jenny, and again put himself through night school, this time earning his JD from Indiana University. They married in 2005 and worked together at a small law firm started by his wife's great-grandfather. Today they reside in Bloomington when he's not here attending to his responsibilities, and they have 4 young children, like I do. Son Tucker, and 3 daughters, Annalise, Abigail, and Ava. And I will say, as a point of personal privilege, the senator and I first got to know each other when he was a congressman, because he has been kind enough to be part of the Congressional Soccer Caucus, and we played soccer together in a fundraiser at RFK. So he supports charitable institutions, as many senators do. Today's topic is one that Heritage has taken a keen interest in, and the Congress has taken a keen interest in every now and then, and that is the authorization for use of military force. One of the most awesome powers that the Congress has under the Constitution, one that Congress has authorized wars 5 times in our nation's history, and declared wars 5 times in our nation's history, and authorized the use of military force over 40 times in our nation's history. The question today that we're delving into is the very fascinating and interesting topic of Senator Young's proposal for an ISIS-specific authorization for use of military force. And I would commend to your reading a paper which we just released, and my co-author Hugh Danilak is here, on analyzing all of the cases out of Guantanamo, the habeas cases, to see whether if President Trump brought ISIS members to Guantanamo, whether the old 2001 AUMF would actually apply, and if not, what the litigation risk would be. So I hope that you read that paper. We're not going to talk much about that paper today. That's not the point. The point is to hear from the senator, who has some excellent prepared remarks. He's been kind enough to agree to answer a few questions afterwards, and then we will thank the senator. He's going to go back to his duties in the Senate, and then I'll introduce our two excellent panelists at that time. So please give a warm heritage welcome to Senator Todd Young.
Well, it's really a privilege to be back here at Heritage, and I want to thank all those who help make these events possible, Heritage's leadership, and particularly I want to thank Cauley for inviting me to be part of this event and for your leadership with respect to law of war policy development and all the thoughtful things that you produce and say to help inform our work. Today, as Cauley said, I'd like to offer some remarks about whether it's time for Congress to pass an authorization for use of military force against ISIS. What many of you may not know is that my time here at the Heritage Foundation came at a historically significant moment, not just historically significant because it gave me a taste of the fine scholarship here, but my last day here at Heritage was supposed to be September 10th, 2001. My successor in my administrative assistant role here at the Heritage Foundation had not formally been trained, and turnover didn't occur, so I volunteered to come back on September 11th, 2001. I was buying a bagel for breakfast at the corner bagel shop that is now closed, and there's a television screen in the corner, and I noted on that screen there was some breaking news. A plane had hit one of the World Trade Center towers. I arrived here at Heritage, not certain what had occurred, but I had some suspicions, and we were told that a second plane had hit a World Trade Center tower. Not too much after that, as I recall events, we were looking out the window, saw a large plume of smoke, which appeared to be rising from the mall right here in Washington, D.C. We later found out that that was the plane that had struck the Pentagon. So if there's ever a full circle moment, I feel like I'm in it right now with respect to my first realization of the war on terror and our responsibility as Congress to make sure that it is carried out in a responsible way. I come to this issue as someone who, as was said in the introduction, spent years in the Marine Corps. I spent 6 years in the U.S. House of Representatives, 2 of which was on the Armed Services Committee. And I now sit on the Foreign Relations Committee, which of course has jurisdiction over authorizations for the use of military force. With that said, I realize this debate has been going on for some time. And there are a number of my colleagues who've shown some real leadership with respect to this matter. Particularly, I'd like to commend Senator Kaine of Virginia, Senator Flake of Arizona for their efforts to be champions when it comes to AUMFs and the need to make sure that Congress not only does its due diligence and communicates about the importance of this issue, but acts in the end. For those reasons, I come to this issue with strong opinions. But please know, I understand I'm not a law of war expert. I have been trained in the law, but my opinions are leavened with a great dose of humility. And you'll be hearing from some law of war experts momentarily. So it's in that spirit that I offer the following comments. I believe it's long past time for Congress to consider and pass an AUMF in its fight against ISIS. Let me give you 3 simple reasons why. The first is, in doing so, we send a clear message to our men and women in uniform that the American people have their backs. As they've done throughout our nation's history, members of our armed forces are once again bravely serving and fighting overseas to keep us safe and secure. On July 4th, 2015, I attended a memorial service just outside of Memphis, Indiana. Memphis, Indiana was the hometown of the first Marine who fell in our war against ISIS. Indiana now has thousands of our men and women in uniform who are directly engaged in one form of combat or another. We have 266 members of our Indiana National Guard who are directly supporting the fight against ISIS. I think we owe it to all our service members in all our branches, our airmen, our Marines, our soldiers, our sailors, whether they're active duty, guard, or reserve. As they confront ISIS, they have to know that Americans and their representatives here in Washington, D.C. stand with them. There's a lot of talk in Washington about supporting our troops, and I support that talk. I think it's important on a very regular basis. We commend, we celebrate, we recognize the extraordinary sacrifices that the men and women in uniform make on our behalf, recognize their family sacrifices, their caregivers. But in addition to talk, we need to, of course, provide resources and training to our service personnel. But we also need to put our rhetorical support into legal action by passing an AUMF. A second reason I believe it's time to consider and pass an authorization for use of military force against ISIS relates to Congress's constitutional responsibilities and the allocation of war powers between the executive and legislative branches. As this audience well knows, Article 1, Section 8 of the Constitution clearly states that Congress has the power to declare war. Yet, 2.5 years after the U.S. began bombing ISIS, Congress has failed to explicitly exercise this fundamental constitutional responsibility. The American people have a right to expect better. Undoubtedly, many in Congress, including members of both parties, have introduced legislation, made good faith efforts to pass an AUMF focused on ISIS. I can't emphasize that enough. Still, the simple fact remains that Congress as an institution has failed to fully honor its constitutional responsibility. As students of history here know, our founders understood that the decision to go to war represents one of the gravest, one of the most serious responsibilities and decisions any government faces. To avoid foolish, hasty, unnecessary, and perpetual wars that tend to accrue debt and erode liberty, the founders wisely divided war powers between the legislative and executive branches. James Madison, who was rightly known as the father of our Constitution for his role in drafting the supreme law of the land, explained why the founders gave the power to declare a war explicitly to Congress. Using the pen name Helvidius, Madison wrote, "A declaration that there shall be war is not an execution of laws. It is not in any respect an act merely executive." Madison continued, "Those who are to conduct a war cannot in the nature of things be proper or safe judges, whether a war ought to be commenced, continued, or concluded. They are barred from the latter functions by a great principle in free government, analogous to that which separates the sword from the purse, or the power of executing from the power of enacting laws." While the founders clearly intended the president to serve as commander-in-chief, the founders granted to Congress an impressive list of enumerated powers related to war, centering on the power to declare war. In my view, the founders intended, and the Constitution demands, that Congress play a decisive role in the decision to go to war, not act as a rubber stamp or a passive observer. Now, for much of American history, Congress took that responsibility seriously, and Cully spoke briefly to this. According to my numbers, divined from the Congressional Research Service, since our nation's founding, Congress has passed 11 separate formal declarations of war against foreign nations and dozens of authorizations for use of military force. Yet since World War II, Congress has generally seemed less inclined to fulfill its constitutional duty and assert its explicit war powers. Now, not surprisingly, this relative congressional abdication has resulted of a consolidation of war powers in the executive branch. Madison would have arguably found this concerning and most unhealthy for our republic. Most agree that the president has the authority to utilize military force in the short term, in cases of imminent national emergency. But no reasonable definition of such an instance should include the engagement of U.S. military forces in protracted hostilities in foreign countries absent a declaration of war or authorization of use of military force from Congress. In short, I believe that this failure by Congress to fulfill its constitutional responsibilities related to war powers isn't good for our country. And third, I share Cully Stimson and Hugh Danilak's concerns regarding the ability to detain ISIS fighters in Guantanamo. In a very well-argued legal memorandum from last month that I encourage everyone to read, they argue that a new AUMF is needed to eliminate any legal ambiguity related to the authority to detain members of ISIS. Law of war detention is essential to keeping enemy combatants off the battlefield, and I say as a former intelligence officer, to gathering intelligence that we need to protect our country. Yet, as the scholars argue, if the Trump administration chooses to detain members of ISIS at Guantanamo, these detainees will likely challenge their detention on grounds that the 2001 AUMF doesn't extend to ISIS. It's not clear at all to me how the courts would rule. We have a legal risk here that needs to be addressed. Passage of an authorization for use of military force targeting ISIS could address this concern. Now, I realize that some very smart people disagree with me on whether or not 2001's AUMF is sufficient to authorize the use of force against ISIS, and this will continue to be something that people of great principle and high intellect will debate. But Mr. Stimson, Mr. Preston, and Mr. Savage, who are here today, will be able to share their views on this momentarily. I'm going to leave that debate to the panel for today. I'll simply say that for reasons related to supporting our troops, fulfilling Congress's constitutional responsibility, and lastly, eliminating any doubt whatsoever related to law of war detention, I believe Congress should act. I'll conclude my thoughts here today by briefly summarizing my legislation. Rather than being a member who just sat around and lamented the fact that Congress has failed to pass an AUMF and took no action whatsoever, I wanted to put pen to paper and put out there what I thought an optimal ISIS AUMF might look like. So on March 2nd, I introduced Senate Joint Resolution 31. This AUMF would authorize the President to, quote, use all necessary and appropriate force against al-Qaeda, the Taliban, the Islamic State of Iraq and Syria, successor organizations, and associated forces, unquote. And to eliminate any remaining potential legal uncertainty, I also included a section that makes clear that the AUMF includes the authority to detain members of al-Qaeda, the Taliban, and ISIS. Believing that Congress should fulfill its oversight responsibilities fully and assertively, my legislation also would require the submission to Congress of a comprehensive strategy to defeat ISIS. In conclusion, I've made clear to my colleagues I believe Congress should act, and I've expressed an eagerness to work with them in a bipartisan manner, as well as a willingness to make principled compromises and take tough votes. I believe this issue is far too important to be mired in politics or congressional inertia. As I wrote in an op-ed earlier this year, An AUMF against ISIS would incentivize greater congressional scrutiny and oversight of the executive branch's strategy to defeat ISIS, establish greater accountability by Congress to the American people, and prevent a further dangerous erosion in the congressional war powers that undercuts the ability of the American people to influence our nation's decisions related to war and peace. So that's why I believe it's past time, for Congress to pass an AUMF focused on ISIS. I thank you again for having me here today, and I look forward to your questions.
Well, Senator, thank you for those excellent remarks and the checks in the mail for the plug on our paper. Kidding, obviously. But we appreciate the fact that you and your staff have read it, and we did put a lot of time into it, analyzing all the cases before the D.C. Circuit on that. A couple questions, if I could. Is there any appetite on the Hill for an AUMF? I mean, sometimes the appetite's there, sometimes it isn't. President Obama introduced an AUMF. I think we got the date wrong in our flyer, but nevertheless, he introduced an AUMF on the Hill. It didn't really get a full hearing. There had been hearings in the years before. What's your general sense of whether there's an appetite today for that debate?
So Congress remains an institution that, in the end, is driven by its members. It really is. And most recently, we saw 46 members of the House of Representatives send a letter to Speaker Paul Ryan. It was a bipartisan letter encouraging consideration of an AUMF over on the House side. I suspect those numbers are a lot larger. Not everyone signed on to the letter, of course. In the Senate side, I noted a couple of people who've been really out front for a period of time with respect to the need to pass an AUMF, and there are others in my private conversations. Leadership will respond to the concerns of their members. I can tell you, as I speak to Hoosiers, they're concerned about this. My suspicion is that Americans from every state understand that the American people themselves need to have a say about this fundamental, incredibly consequential decision about whether or not we send our nation's best in harm's way. So I do think that there's a growing appetite. Allow me to characterize it that way. And now is the time to lean in on this, as the world only appears to be getting more dangerous on a number of fronts.
Yeah, you correctly pointed out, obviously, that the Congressional Research Service noted that there have been 11 specific declarations of war in Congress's history. We lay out those 11 in our paper in 5 major conflicts. And then 40-plus authorizations for use of military force, some of which were very narrow, like against the Barbary pirates off of here, or very narrow ones. This 2001 AUMF is rather capacious compared to some of the other AUMFs. Do you see, as a member of the Senate Foreign Relations Committee, a path forward on your committee? In other words, is there an appetite on the committee to sort of take this up and move forward?
Well, when I first brought this up in one of my first hearings before the Foreign Relations Committee in January, I wasn't certain. I saw some affirmative nods as I discussed the need for us to finally pass an AUMF. But then in private conversations, I discovered that everyone recognizes this needs to happen, maybe with some exceptions. Or let me restyle that and say that I think everyone recognizes it would be optimal for Congress to speak on this particular issue. There's some pragmatic concerns, and those are legitimate, that we would unduly constrain the ability of this commander-in-chief or a future commander-in-chief to conduct military operations against ISIS or the other groups we list in the authorization for use of military force in a manner required to actually defeat them and achieve our objectives. And so there's tension here between those who understand that constitutionally we have a responsibility to do everything we can to sanction the authorization use of military force, and members who, frankly, don't want to tie the hands of this or a future president. But I think through principled compromise, we can end up in a good spot here and keep faith with our men and women in uniform and still make sure that we don't just delegate to the executive branch war-making powers. I think there's something else that needs to be said with respect to this exercise. Merely going through the debate in a public forum requires us in Congress to sell the need to go into battle to the American people. If we can't do that in a democratic republic, right, then perhaps we ought not be going into battle. And that's the responsibility of the president, but not the president alone. It's the responsibility of each of us in Congress. And so I think merely having this debate would be a real service to the American people.
Well, I appreciate that, and that's in talking with your staff in the run-up to this panel event. I mean, the role we play as a 501c3 educational institution is to try to stimulate debate and discussion, and I'm very grateful. Can you stay for a couple of minutes for
Oh, sure.
couple
Yeah,
questions?
absolutely.
Okay.
Yeah.
So the rules of engagement are the same rules of engagement we have for all distinguished speakers at Heritage. Delighted to take your question. Just please raise your hand, identify yourself by name and organization, and actually ask a question with a question mark at the end.
All hard questions have to be submitted by email, right? All right, so-
I'll start with Paul Larkin in the back, my colleague.
Thank you, Senator. My name is Paul Larkin. I'm a fellow here at Heritage. In your opinion, what is the difference between a congressional declaration of war and a congressional AUMF? And when would you choose one over the other?
So an authorization for the use of military force, as colleagues sort of alluded to, can either be fairly narrow in scope, if that's how Congress tailors it. One example would be the quasi-war in the 1790s, where it was incredibly limited, the action to be taken against the Barbary pirates, right, who were targeting our merchant vessels. At the other end of the spectrum would be the Gulf of Tonkin resolution, which some scholars have argued, and this is noted in Cawley's piece, some scholars have argued that was effectively a declaration of war because of the breadth of the legislation. But if one were to declare war, it's essentially, it's incredibly broad in scope. It allows the president extraordinary discretion there's almost nothing circumscribing it to seize assets and to accomplish the objectives behind that war.
And I would note that there's an excellent Harvard Law Review article on this by Curtis Bradley and Jack Goldsmith going through all the declarations of war and the AUMFs, and they conclude, among other things, that declarations of war tend to be out of favor because of the change in custom international law. And I know you love law review articles, so I'll give you a copy of that when I see it. Sir, in the front here.
Hi, sir.
And who doesn't love law review articles, right? Yeah.
Senator, as a graduate of a Quaker college in Indiana, I'm particularly glad to be here today. I'm Jim Kaysen. I am the Foreign Policy Director at the Friends Committee on National Legislation. And I want to first thank you for the letter you sent to the Saudis last week on the human rights situation in Yemen. And I wanted to ask you particularly about sunsets, because as Mr. Simpson mentioned, the 2001 AUMF is very broad and seems to be going on kind of without any congressional review at all. In your legislation, do you consider the issue of when it might be sunset and how Congress revisits the issue?
We do not. I struggled with this, frankly, because the downside, of course, to sunsetting is you allow the enemy to figure out when you're going to disengage and when your will might break, and you'd prefer the enemy not know that, right? So my preference is to give broad discretion to the commander-in-chief in that regard, lay out the objectives, and and then go out and accomplish those objectives. I acknowledge there is another side to this, and I think this would be a healthy debate. I spoke about the need to avoid perpetual wars. I think we can avoid a perpetual war by delegating broad discretion to our commander-in-chief, ensuring that's a robust strategy which is sufficiently resourced, and then if there is another enemy later that needs to be defeated or degraded, we take up a distinct AUMF.
I think we have time for one more question. Anyone else have a question? Charlie Savage.
Hi, I'm Charlie Savage with the New York Times, but also
Hey, Charlie.
on the successor panel. Actually, I wanted to follow up on both of those questions with because it seems to me there's a little bit of a tension between your desire not to have a perpetual war, but also including explicitly successor organizations in the language of who you're authorizing war against or military force against. And then also, I was curious that you said that when you raised this with colleagues, some of them thought that to pass an authorization like the one you're proposing might actually constrain President Trump. And I don't see, the constraints we've heard in this argument have been Obama's suggestion of a sunset and also a limitation on ground forces. It doesn't sound like you have either of those. What constraints are in yours that A, are giving your colleagues pause, and B, would prevent this from being a perpetual war? Thank you.
Yeah, thank you. So the constraints we have are congressional oversight, which we have abdicated to the executive branch. Then the American people can hold people like myself to account for the decisions we make, and that's not a one-off deal. That's moving into the future. If the American people indicate, recognizing that Congress has ownership over the decision to go to war, if they indicate that they're not happy with the conduct of that war, then we try and reflect that in policy if we can't persuade them of the merits of going another direction. With respect to the perpetuity possibilities in our version of an AUMF, we do indeed, as you said, include successor organizations to Taliban, al-Qaeda, or ISIS, recognizing that if one merely changes their name, or if another organization is tightly affiliated with one of those entities, then the war can continue. But this leads to, this could lead to a longer conflict without doubt. But the mission isn't really accomplished, let's face it, if a successor organization continues to threaten the safety, the welfare of the American people, our allies, our partners, right? So, all this is consistent with my belief that when the United States goes to war, we go to war to win, right? And we ought not set artificial timelines, and in a sense, we ought not establish an artificial barrier to going after a hostile organization which may have slightly changed over a period of years. Yeah.
All right, please join me in thanking Senator Young.
Yeah.
Thank you very much. And our traditional gift is a heritage tie, which of course falls well under the ethics rules. Hope you wear it on TV next time.
Great, thank
very
you.
much.
Thanks
All
so
right.
much, Colin. Yeah.
Just give us a sec while we switch things out here, folks. And I'd ask Mr. Preston and Mr. Savage to come up, please.
Thank you.
Grab the ties here, Steve. A few years ago, during the Obama administration, I had the very high honor and privilege to befriend Jay Johnson, who was at the time at the Pentagon running the transition before the Obama administration came to power on January 20th. And Jay and I had a series of discussions over several years, and he was kind enough to come to Heritage while he was the DoD General Counsel and gave a fascinating speech on the administration's position with respect to detention policy. This was one of many speeches that the Obama administration senior government officials gave over the course of 8 years, all of which have been pulled together in various publications, and I commend them to you to read. And that's why I'm particularly pleased that Stephen Preston and Charlie Savage, but Stephen Preston in particular, who was in the Obama administration, kindly agreed to come by and spend some time with us. Mr. Preston is a partner at Wilmer, Cutler, Pickering, Hale, and Dorr, where he heads the firm's defense, national security, government, and government contracts practice. His work includes investigations, litigation, federal procurement, civil fraud, foreign investment in the United States, cybersecurity, strategic counseling, and crisis management. From 2009 to 2015, Mr. Preston served as General Counsel of the Department of the Defense, and before that, General Counsel of the CIA. I would note the only person to hold both positions. During his 6 years in the administration, he played a leading role in ensuring that the United States intelligence activities and military operations fully complied with domestic and international law, and he was a key legal advisor on many of the country's most challenging and consequential national security endeavors. He previously served in positions at the Pentagon and the U.S. Department of Justice between 1993 and 2000, including as General Counsel to the Department of the Navy from 1998 to 2000. When not in government, he has practiced law at Wilmer Hale, including between 86 and 93, and from 2001 to 2009, of course, again today. Not surprisingly, for his contributions while in office, he has received the highest awards presented to civilians by the DoD and CIA, as well as the State Department, the Office of the Director of National Intelligence, and the Department of the Navy. He writes and speaks widely on topics relating to law and national security, and in 2015 received an adjunct faculty appointment to teach at the Yale Law School as the Oscar E. Rubenhausen Distinguished Visiting Lecturer in International Conflict and Security Law. He was appointed to the President's Intelligence Advisory Board in 2016. He received his bachelor's degree from Yale University and his law degree from Harvard University. Let me introduce Charlie Savage, who, by the way, wrote this, among other excellent books, and this one's entitled Power Wars Inside Obama's Post-9/11 Presidency, which I reviewed, among others, on Lawfare blog. Charlie Savage is a Pulitzer Prize-winning journalist and is the Washington correspondent for the New York Times and has been covering post-9/11 legal policy issues since 2003. Also a Hoosier, he is a native of Fort Wayne, and he graduated from Harvard College and holds a master's degree from Yale Law School. His first book, Takeover, a best-selling and award-winning account of the Bush-Cheney administration's efforts to expand presidential power, was named one of the best works of 2007 by the Washington Post, Slate, Esquire, and other institutions. So please join me in welcoming both Mr. Preston and Mr. Savage. I thought we would start off by going back in time a little bit, if we could. The senator gave his 3 reasons for Congress for Congress reasserting what he believes is their constitutional role in the authorization for use of military force against ISIS. He said that, 1, it sends a message to the troops, that it's their constitutional duty, secondly, and third, he thinks that with respect to the more limited issue of detention at Guantanamo, it might add more legal clarity to that. Let me just start broadly with your reaction to his comments and anything you want to add to them. And I'll start with you, Mr. Preston, and then move to Mr. Savage.
Great, I'd be happy to. And before I do that, let me thank you, Kali, for
the opportunity to be here.
Sure.
And thank you for your contributions to the debate, the public debate about national security law issues as evidenced by your most recent paper. And of course, and for your service as a naval officer. Very grateful for that. And let me also say what a privilege it is to share the panel with my friend Charlie Savage, who has done so much to report on the role of law and legal policy in national security, but also to elucidate those issues for the reading public. So I'm very pleased to be here. To respond to your question, and not surprisingly to me, I found myself very much largely in agreement with the senator. I think we can all remember back in the summer of 2014 when ISIL, whatever we want to call it, captured the attention of the United States and of the world with appalling displays of brutality, including the gruesome murder of U.S. citizens held captive in Syria, great swaths of land, territory falling to ISIS in Iraq. And it was imperative at that time for the president on behalf of the United States, to order the use of military force to address the threat to the region and to our interests and people as well. And the president did so expressly on the authority of his authority as president and commander-in-chief under Article 2 of the Constitution. But then under the War Powers, the Nixon-era War Powers resolution, there was raised the question whether Congress needed to authorize the use of force against ISIS, or whether that authority, congressional authorization, was embodied in the existing legislation. And it fell to the lawyers in the administration in the first instance to examine that issue, which we did intensely. And we concluded, the administration concluded, that both the 2001 AUMF and the 2002 AUMF with respect to Iraq provided authority for the actions that the president was ordering in Iraq and Syria against ISIS. I believe then, I believe now that that was the correct conclusion, and I assume that it is that conclusion that provides the basis for our government to continue to prosecute the fight against ISIS. But I also firmly felt then, and feel as strongly now, that it was important, I would even say imperative, for Congress to act, for Congress to carry out its constitutional role in the war fight, the decision to take this country to war. Not because at the time it was necessary in order for the military action to be lawful, but as the senator underscored, it's important in our democracy and our government of shared powers for Congress to play its role, to fulfill its constitutional responsibility here. And I think it was also important as a practical matter, again, as the senator pointed out, to demonstrate that our government was fully behind this fight, demonstrate to the men and women of our armed forces who are fighting the fight, but also to demonstrate to the American people that its government, our government, it was united in its support for the fight. And also importantly, the senator didn't mention, but I expect would agree, to demonstrate to our partners and to our adversary that this government and our country is united in the fight. So to answer your question, circle back to your question, I think that seems to be what is animating the senator's resolution. It certainly is a theme he was sounding in his remarks, and I'm in agreement with that.
Charlie, the question's on the table, and if you want to pick up anything Stephen said, please do.
So two things. One, I was struck that he didn't really, the senator didn't, at least in these remarks, make the case about why some people are uncomfortable with the idea that the existing use of force authorizations cover the conflict with ISIS. And so just for the audience or whoever's watching on C-SPAN, to quickly summarize, ISIS grew out of Iraq's al-Qaeda affiliate that ran the insurgency against us from 2003 on, but it is no longer part of al-Qaeda. the two groups have had a leadership split after Osama bin Laden was killed, a disagreement not just about who should be in charge and who is the rightful heir of bin Laden, but also about deep strategic issues. Should there be a caliphate? Should we hold territory now? Are we being too brutal to other Muslims, and when we should really be keeping the Muslim world united against the West, and so forth? And in fact, they're literally at war with each other. What used to be until 10 minutes ago known as the Nusra Front, which is al-Qaeda's affiliate in Syria, is literally killing and being killed by the Islamic State. And so it seemed bizarre from that vantage point when the Obama administration first brought out the theory that these groups that were literally at war with each other were the same group or were associates of each other enough that the same war authority covered both of them. And clearly no one in 2001, when Congress authorized the use of force against the perpetrators of 9/11, was thinking about a conflict 15 years later in Syria. And then the Obama administration put less emphasis sort of on the 2002 Iraq AUMF, and even now the senator didn't bring those up. In some ways, I think that authority might be cleaner. This is still, the cleanup from the decision to invade Iraq in 2003. But the discomfort, at least with the previous administration, was they had declared that they had gotten out of the Iraq war. And Susan Rice, the National Security Advisor, had said explicitly that the government was no longer relying on that authority and Congress should clean up the books by rescinding it. So it was odd then to suddenly be relying on it, or at least saying it was there as an available reserve thing new. So that's why this has been an uncomfortable thing since. But why did the Obama administration first put forward this theory, that as Stephen described? Why is it? I think that resonates with something else that was interesting about the senator's remarks, sitting and listening to them in the audience, which was he didn't actually say it was necessary, right? And his first argument for why Congress should now do this is it will make the troops feel better, we're behind them, which is a very soft argument, right? So it would be a nice, aesthetically nice thing to do. And maybe if the Trump administration wants to bring an ISIS detainee to Guantanamo, it would remove some of that litigation risk of whether this authority does extend to this kind of a detainee. But he didn't say, he was unwilling to say, you know what, that authority does not cover this war. This is an unconstitutional thing that now two presidents have been engaged in. And by God, we've got to clean it up and do our constitutional duty by, in fact, providing real authority for this thing that's been happening for 2.5 years. And I think the reason he didn't do that is he doesn't trust Congress to do its job. He wants them to. He's trying to persuade his colleagues that it's time, the long past time. But he doesn't want to go out on a limb and say, if you don't, this war has to end because it's unconstitutional. And in the same way, back in 2014 in late summer, President Obama was faced with this national security imperative, as Stephen described it, and did not trust Congress to come back heading into the 2014 midterm and actually pass something. And so the choice was do nothing, because the War Powers Resolution was going to bite before Congress got its act together, or do something and come up with a good enough theory. And that's what they did. And I think that unwillingness to trust Congress to actually move continues to infect this debate. Because as you don't say it's necessary, it's going to be very hard to get Congress to act in something that's so controversial, where who knows where 5 years from now what the war will look like and whether it's popular or not. Look how much John Kerry suffered with his left flank for having endorsed the Iraq war. So unless enough members of Congress are willing to go there, which apparently they continue not to be in terms of trusting their institution, there's not going to be a really resounding sense of urgency that this must happen, because otherwise something has to get turned off.
Let me add to that, and I'll ask either of you to jump in. If my recollection is correct, when your boss, President Obama, sent the AUMF up to the Hill, there was a transmittal letter. And in the transmittal letter, if I recall correctly, it said, although I already have the authorization to conduct this war, I still recommend blah, 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 blah. You're putting your finger on part of that, and that is that there's this sense on the body of some in the Senate, and probably in the House too, that if it ain't broke, you don't need to fix it. I mean, the 2001 does adequately cover this, and why do we want to sort of do this if it's not legally required? Could you speak more to that? I mean, that must have been a hard thing, because here you are in an administration that is taking kinetic action against the enemy, and in my opinion, fully covered by the 2001 AUMF. But from what I could see from the outside looking in, wanting to engage Congress to get engaged and fulfill their constitutional responsibilities for not only the reasons probably that Senator Young points out, but also that it's a matter of congressional hygiene, that they have skin in the game, that they are recognizing that ISIS grew out of al-Qaeda in Iraq in 2004. There was a formal split, I believe, in 2012. They're really going off in their own direction, and this makes more sense. Could you put some more words around that?
So it seems to me you have to be careful to say that a new AUMF was not necessary at the time in order for these military operations to be lawful is not to say it is merely desirable to have an AUMF. I used the word earlier, imperative. I think it's imperative not as a matter of legal necessity, but as a matter of the proper functioning of our government and a number of the other subsidiary factors that we discussed. Another sense in which as time passes, it may go from not just desirable or imperative in the sense that I've described, but legally necessary, is as the adversary evolves. At the time we addressed this issue, we were dealing with what had been called al-Qaeda in Iraq, AQI, a terrorist organization that was a component of al-Qaeda up until the differences between the leaderships that was operating in Syria and Iraq. Now we have ISIS or manifestations of ISIS in Libya, Afghanistan. I don't know where Boko Haram is nowadays. And both the 2001 AUMF and the rationales under the 2001 AUMF are not infinitely elastic to reach the adversary, no matter what it is or how it manifests itself. So I think if you take a longer view, it's imperative as a matter of the proper functioning of our democracy, but there are also legal reasons it would be wise and advantageous to the current administration to secure a new and express authorization.
Charlie?
Well, I mean, I think maybe I quarrel a little bit with the notion that it's not legally necessary, but it's still part of like the core constitutional functioning of our government. Because if it's not legally necessary, then that means that the core constitutional function of our government is that Congress's war power is purely ceremonial. They need to be seen to be blessing the thing that that can happen without them.
Well, they could repeal the 2001 AUMF if they decided in the exercise of their constitutional role that war should end. In exactly the same manner, they can act to endorse the fight as it has evolved post 9/11.
That's
so
right.
I disagree with that.
Well, okay, but if they don't repeal it, then then everything is fine, right? The other piece of this, just for sort of public education purposes, that's interesting to me is the fact is that Congress has acted repeatedly in this area since 2014, because knowing how the executive branch is interpreting its authority under the 2001 AUMF, it has repeatedly authorized funds for the counter-ISIS operations. And so one of the interesting things that's very complicated about all this is that even if you are among the faction that thinks that the administration's original assertion was edgy and maybe stretching the AUMF too far, it may be that problem has healed over time because Congress has essentially ratified that theory by continuing to appropriate funds explicitly for the counter-ISIL operations, which amounts to authorization. And this is one of the problems that Senator Young and Senator Kaine and others may have, that as time continues to pass, 2.5 years now, 3 years, this is the opposite of urgency. And whatever sort of, when we think about, when he was reading from Madison's comments about how the need to separate the power to decide whether to go to war from the power to execute war, since running a war tends to accrete power to the executive and so forth. The damage is sort of done if there was damage. And at this point, it may be that the scab and the scar tissue has already formed. And so the cleanup of the legislative books by having Congress explicitly say ISIL and successor organizations, whatever that means, I'm not quite sure what problem is being fixed as much today if this ever were to happen. Just throw that out as a note of gloom.
One of the things I argued before the Senate Armed Services Committee when they had that big hearing back in 2013 on ISIS, AUMF, and the law of war and the law of armed conflict was, in my written testimony, was that the 2001 AUMF is self-limiting, and that it's not as broad and capacious as some would argue. Now, this gentleman asked the question that many people have, which is, it seems like it's going on forever. One associated force becomes the next associated force, et cetera. Your predecessor and our friend Jay Johnson gave a speech at Yale Law School, which you talk about in your excellent American Society of International Law speech on April 10, 2015, where you said, when he was talking about associated forces, quoting him, that an associated force must be both, quote, an organized armed group that has entered the fight alongside al-Qaeda, and two, a co-belligerent with al-Qaeda in hostilities against the United States or its coalition partners. And then you go on to say that this means that not every group that commits terrorist acts is an associated force, and I argued the same. I think most law of war scholars believe that. I mean, we're not talking about Hezbollah or this group over here that just changed their name to something else if they're not associated with al-Qaeda. I'm not going to burden you with this question. I'm going to ask you, Charlie, as a reporter. I asked the senator what the appetite on the Hill was for passing an AUMF. And I agree that Senator and others have really done a good job trying to tee up the question. How would you answer the question that I gave the senator? I mean, really, is there the appetite there? And I've argued that an AUMF is not a substitute for a comprehensive strategy. It's simply the legal underpinnings to authorize a strategy. You want to pick up any part of that question?
Well, just observationally, the thing that prevented Congress from, everyone in Congress essentially supports fighting and defeating ISIS. Like, there are no pro-ISIS or even let's stay home and let them solve their own problems because they come here and attack Paris and so forth, and everyone can see that. But so why didn't Congress pass an ISIS authorization in 2015 when the Obama administration sent it up? And the reason was there was a split between what the administration wanted, and what Republicans who controlled both branches wanted. The administration wanted a sunset. The administration wanted a limitation on the use of ground forces in enduring offensive operations or something. There was some sort of formulation that was intended to allow some limited use of rescue or whatever, or commando raids, but not occupation. And the other view was, no, if we're going to go to war, you don't tie your own hands at the onset, you do everything. But then because of the experience of the 2001 AUMF and the sort of evolving, morphing, mutating forever war that's grown out of it, on the left, there was less appetite for that, and let's not do that again. And because there was no one saying we have to stop if we don't get something, because the administration was saying the existing authority was sufficient, this conflict could not be resolved. There was not going to be something that Congress could pass, that president would sign, and so that it was just easier just to not do anything. So now we have a new administration who would presumably sign a more open-ended AUMF, like the one the senator is proposing, without ground forceless limits, without a sunset. It seems like the conditions are there to clean this up as part of the next National Defense Authorization Act or something. Very few people are talking about it. There's a lot going on in the world and a lot going on in Washington that maybe seems more urgent. Nevertheless, I wouldn't be shocked. I would not be shocked to see some language not unlike the one that he was proposing folded into the NDAA that Congress deals with at the end of this year, despite the fact that we're not hearing much about it. Just because I don't see where the opposition to it is organized in the sense that Obama wasn't going to sign that bill. Trump will sign the bill. I don't know. What do you think?
So as I think about judging a new AUMF, from my perspective, the highest priority is on certainty and clarity as to what the authority is. And that resides, in terms of a follow-on AUMF, in defining who the enemy is. Mm-hmm. And then there's, beyond that, you want it to be adequate, sufficient to meet the threat and the foreseeable threat, and tailored to the immediate and foreseeable threat. And I think there is a concern, at least among a good number of members, about a blank check type authorization. And that then leads to consideration of various limitations: geographic limitation, a mode of fighting limitation, temporal limitation, and others. And the former, I think, are particularly problematic in that they tend to erode clarity as to what the authority is, and may erode the utility of an AUMF to meet the foreseeable, if not present, threat. I think the time limitation, the sunset concept, is entirely different. And if properly structured, isn't really a limitation at all. If properly structured, it is a public embrace of our democratic system where Congress and the President have to agree to initiate conflict, and this would be structured in a fashion to periodically reaffirm our commitment to that fight. So I think, if it's a 2-year limitation, that may have the effect and may signal to others that we are not committed to the fight. But I could foresee a sunset provision that places the sunset somewhere, perhaps a presidential term away, and creates a mechanism for renewing the authority in advance of the sunset, such that the public, our partners, the adversary, are not being messaged that we're not committed to the fight, but rather that we're committed to our democratic institutions, and we have set up a mechanism to fight this fight as long as we have to fight the fight. And I think, to the extent that, as a practical matter, in Congress, there are those that are uncomfortable with the blank check, and there are those that are uncomfortable with excessive limitations, I think a properly structured time limitation actually could be a point of compromise.
I could just add on one thing there. I mean, you're starting to put your finger on why this is so hard. So he names in his Taliban, AQ, and ISIS, but then associated forces, whatever that means, and successor organizations, whatever that means. But then, so does the fact that he didn't name al-Shabaab or didn't name Boko Haram mean that Congress, when it had an opportunity to do so, was deciding, or AQAP or whatever, that those organizations, or these little ones that no one's ever heard of that are all running around, tribal Pakistan, TTP, and so forth, are they not part of it, or you're still ceding to the executive branch the decision to just deem someone tomorrow part of the fight who wasn't part of the fight today, and then you're not really solving the problem? And so there's been various efforts to grapple with that, and how do we need notice or some kind of conditions that are statutorily must be met? And then the other part of the blank check problem is it's not just that Congress thought it was authorizing war against al-Qaeda in Afghanistan in 9/11, and now it's being used to fight Shabaab in Somalia and AQAP in Yemen and ISIS in Syria and so forth, that it sort of spread. But there's a history of using that authorization to do all kinds of other things, like have a warrantless surveillance program on domestic soil, because that's the Bush administration decided the AUMF authorized, going around FISA, and what else could it be used for? And so this is also part of the blank check anxieties that drive, well, maybe we need to put a lot of limits in it, and other people are, well, we don't need the limits, and it becomes so hard that it's easier just to go with the existing theory that whatever's happening is fine, and let's not open this Pandora's box. I don't think that the language the senator proposed in and of itself is going to meet those anxieties, because it seems so very broad and open-ended to me, that it will attract alarm.
Let's pivot, if we could. I referenced Jay Johnson's speech here and the Obama administration senior government officials' speeches around the country explaining the legal rationale for various aspects of what some call the war on terror. Charlie, you're a journalist. You won the Pulitzer Prize. That must be nice.
Long time ago now.
You wrote about it extensively here in Power Wars. Did you find that helpful, and if so, why? In other words, does it make more sense for an administration, given the complexities of the war, for senior government officials in a methodical, step-by-step approach to go in the public and try to explain to the extent practicable and possible the legal rationale for various actions they're taking? And then, Stephen, if you're able, and if you're not, I understand, looking back now, did it meet the objectives you hoped it would serve? And I'll start with Charlie.
So the Obama administration did things that were edgy and things that were controversial from both of its flanks in the area of war powers and national security law. But as a general proposition, it saw a broad need and advantage in trying to explain itself. And it wanted to be seen as an organization that took seriously the rule of law and was grappling with these very difficult issues that have arisen in the 21st century, where it's not always clear what the law is. Often the law was written for situations that are different than the ones we're facing today, and you have to sort of interpret it by analogy, and there may be multiple plausible interpretations, but then also some implausible ones, and they wanted to show that they were staying away from the crazy ones, at least. And they engendered through that a lot of public debate that I think was good for democracy, even if people didn't always agree with what they were doing and where they came down on things like, is ISIS covered by the 9/11 authorization? To date, this administration has not been that way. It's not so. And the great example of that, we're only 100 and whatever days in, but Trump shot missiles at Assad's forces in Syria and offered no public rationalization for why he had legal authority to do that, without, especially in international law, without a UN Security Council resolution, without a self-defense claim. A very edgy thing to do. The Obama people thought when they came close in the Red Line episode, they thought they had an argument for why they could do that, but it was a thin one. I think even they would acknowledge. At least this administration seems to see no need even to explain itself. And that's not good for democratic accountability and public debate, and I hope that they evolve on it.
So my sense of it is, first, I think, as you suggested, it was part of President Obama's philosophy of governance and view of the government that there should be as much transparency as possible, as much transparency as possible, and to include in matters of national security within the confines of preserving national security. From my perspective, it was a much more practical proposition. When I started in government in July of 2009, you couldn't pick up a newspaper without front page references to the latest strike as in Southwest Asia, pursuant to our government's illegal counterterrorism program. It was as if it were conventional wisdom that what our government was doing to fight the terrorists in Afghanistan and elsewhere was part of a secret illegal program. And it was disturbing to me to have it characterized that way. And I saw that as horribly corrosive in our system of government and in terms of public support for what our country was doing. But also potentially quite harmful for the rank and file people that we were asking to fight this fight, to have some widespread perception that these efforts were unlawful. It was also equally disturbing to me that there was a constant refrain it was unlawful and no one seemed to care. But from my perspective on the inside, it was important to articulate for our government, to articulate to our people why it was doing what it was doing and what the legal basis was for it. And you saw that in speeches by the State Department legal advisor in 2010, and then the Attorney General's speech, in which he not only explained the domestic and international legal bases for our counterterrorism program, but also addressed the lawfulness of using force against an American citizen who chooses to take up arms against our country. And I think the end product was, you asked about whether it was effective. On the matter that concerned me initially, this conventional drumbeat in the press and among some scholars that our country was pursuing an unlawful counterterrorism program, that fell out of the public debate. You stopped seeing that. Not that everyone was convinced or that all critics will be satisfied, but I think there was a broader understanding and wider acceptance of the lawfulness of our government's counterterrorism activities than there was without that type of transparency.
Yeah, I will just say, as a person who spent a little time at the Pentagon in the Bush administration, we certainly didn't do a very good job explaining the legal rationale for detention operations early on. In fact, we were pretty bad at it. And I think we started turning the corner in the second part of the Bush administration when John Bellinger, who was the legal advisor, the head of the legal shop at the State Department, gave a series of speeches, one of which really stands out in my mind, which is his Halloween speech, 2006 at the London School of Economics, where he really explained to our partners the legal rationale. And I think we probably should have done more of that, but John did yeoman's work. And watching the Obama administration from the sidelines at a think tank, I thought it was rather helpful, understanding where you were coming from in the legal justification. And I found President Obama's May 21st, 2009 National Archives speech particularly helpful, because that really set the table, at least on the detainee side, of how they were going to try to solve that problem. These are tough issues. Well, we have a little time for questions, and if anyone has a question, please raise your hand, and again, identify yourself by name and organization and ask a question. Here in the front. Wait for the microphone, please. Hugh, it's right here in the front. Oh, somebody has, okay.
Right in the middle. Chris Harland with the International Committee of the Red Cross. Thank you very much for putting on the panel. And thank you for the paper as well, which I thought was good and very interesting. You conclude in the paper, I think, that the United States should have an AUMF before bringing Islamic State group fighters to Guantanamo because of the risk that you outline. You mention, I think you say that there might be a successful legal challenge and that it's unclear currently. I wonder if you might say a couple of words about that, and maybe the other panelists maybe discuss that potential risk as well. And maybe just if you have any thoughts, there have been some people who've been writing the fact that new detainees to Guantanamo would not, under the current system, would not get a periodic review board set up under the executive order that does that for the current detainees, and whether you think that would influence judges in the D.C. Circuit and elsewhere in having to assess whether or not the people were there legally, or whether that's simply a separate question and wouldn't play any role in it.
Yeah, well, thank you. I'll take those questions in order. And we didn't cover the periodic review board issue, and I think it's an important and related concern, but we just didn't have enough ink or space to cover it. You would think that in the time I've spent at the Pentagon and since then, I would have analyzed every single case out of the D.C. Circuit and come to some conclusion about that. Well, I hadn't. until we had done the analysis and tried to categorize the buckets, for lack of a better term, that each detainee fell into as the D.C. Circuit analyzed and had to decide on their writs. And I hearken back, when I was at the Pentagon, as you know, we had a close working relationship with your organization, and it's a very important relationship, and the government still does, as I understand. The Bush administration had almost a perfect record before the Supreme Court. We almost lost every case. You tend to remember your losses. And hopefully, if you're a sentient individual, you think about why you lost and what set the table to that litigation and how you can avoid that in the future. So perhaps it was the litigation risk-averse side of my personality. But having been a defense attorney and a prosecutor and a judge, I tend to think, hopefully, through all sides of a litigation. And we picked up on the dissents that several of the judges said in this D.C. Circuit cases, and I think the further we get away from 9/11, there's been an interregnum, obviously, in terms of the time people have been brought to Guantanamo. I mean, the Obama administration didn't bring one person, which was entirely their right not to bring anybody to Guantanamo. So there has been no ISIS member brought to Guantanamo. And so I think we prudently concluded that the litigation risk is well above zero, that certainty is better than lack of certainty, which Stephen and others have stressed, and the senator stressed, which was very kind of him to do so. I don't know what Charlie and Stephen think or whether they've read the paper, but I think that when you look at the litigation, just the habeas litigation, and you look at who these ISIS members are, and I don't know who they are. I haven't seen the intelligence. I haven't been in the government for a long period of time. I can imagine that trying to connect the dots as the government lawyer between this particular ISIS member back to the core group of people who could fall squarely under the 2000 AUMF might be a heavy lift for a government lawyer to do. And so that's the conclusion. And to your second part of your question, I don't know what this administration is going to do with respect to the periodic review boards. We had periodic reviews, as you know, during the Bush administration. It was called something different. It was called the annual review boards, ARBs, A-R-B-S. And I would certainly hope that this administration would review detainees' files on a regular basis. I don't know if they are. I suspect they may be. And I think that would probably factor into a court's analysis, especially if counsel for the detainee brought that to the court's attention. But how that would turn out, I don't know. And I would invite any of my colleagues to comment if they want.
I just add, I did read the piece, and as I mentioned earlier, I think it's a useful contribution to the debate, and analytically, a sound treatment of those cases. I have no disagreement on it. I am concerned about the implications of citing the ability to put detainees at Guantanamo as a reason to have another AUMF, for the very practical reason that that is a political lightning rod. And harking back to our earlier conversation, I think it is a desirable end state to have the executive and the Congress agree on the warfighting authority here, and to have Congress's participation be bipartisan if at all possible. And Guantanamo, like it or not, has become a political lightning rod. So to the extent that if I were strategizing, if you will, with Senator Young about getting a resolution passed, I don't think I would highlight it as a reason to pass it, enabling this administration to bring ISIS fighters to Guantanamo. I think that might undermine a goal of trying to get bipartisan support.
Yeah, I totally agree. I think that's actually a tail wagging the dog problem, and it goes to Charlie's original point. What's the real rationale? What's the legal basis? What is the real need to do so? Charlie, you want to jump in?
Oh, I think that point is shrewd, and yet at the same time, that's the place where you get a hook, right? You better do this because you're screwed up if you don't. or you're taking the risk. So if you take that off the table for political reasons, then you're sort of back in this purely aesthetic, wouldn't it be nice, wouldn't it send a warm and fuzzy message to the troops, which is hard to get any individual lawmaker to then cast the hard vote that might come back to haunt him or her later when you don't have that, boy, we better do it or else the government will be screwed up in some way argument in your quiver.
Yeah. Any final thoughts from either of you?
Thanks very much for having this. This is a pleasure.
Well, this has exceeded my expectations. You've been wonderful. I appreciate both of you taking time out of your very busy days. And please join me in thanking this panel.
Thank you.
Thank you very much.
Is this a tie?
It's a time. Awesome. The next time you're on TV.